Pursuing Garnishee proceedings in Nigeria to enable judgment creditors reap the fruits of monetary judgments awarded in their favor is quite complex in Nigeria. Operators in the commercial legal sector are now calling for speedy reforms and an amendment of the enabling law. Kemi Falademo has more.
The High Courts of Nigeria are empowered under the Sheriff and Civil Processes Law of 1945 to hear Garnishee proceedings, which is a judicial process of enforcing monetary judgments whereby monies belonging to a judgment debtor in the hands of a third party known as the Garnishee, usually a bank, is attached or seized by the judgment creditor in satisfaction of the judgment sum. The current practice amongst judgment creditors is to join all the banks operating in Nigeria as Garnishees, which stakeholders say creates inefficiency, delays, and sometimes unjust results.
A lot of banks they spend millions, billions even, in trying to defend judgments that they don't have, defend orders in which they don't have monies in their account. So I think the court has balanced it more in favor of the Nigerian citizen. But there's a need to, because business has to grow for an economy to grow.
Debts that the bank owes, that the judgment debtor owes to the bank should not be attached. There's actually Supreme Court decisions that actually say so. So these are things, but even in spite of this clear jurisprudence, we still find instances where the court perceives that there's some form of collusion, and still go ahead to make it absolute, and it's really unfortunate.
You appeal against the judgment, you file your stay of proceedings. But despite all these processes that you filed, you notice that some courts, they will still proceed with the Garnishee proceedings to go to the extent of making it absolute, telling you that the Garnishee proceedings is different and that you have not appealed against the Garnishee proceedings. You've just appealed against the judgment. But that is not the position of the law.
This roundtable discussion, made up of relevant actors such as company secretaries, lawyers, the judiciary, and regulators, is also geared at proffering optimal solutions to the problems with the Garnishee process.
We're looking for what is fair and what is balanced. We're not saying give the banks all that they want, but recognize their pain points and fashion out a solution that works for everyone, including the creditors, the lawyers who represent them, the banks, and the regulators and the customers.
There must be rules and regulations about a judgment creditor having to bear the cost of an innocent Garnishee. So if a Garnishee comes to the court and says there is no money with me and they've gone through that expense, the judgment creditor must bear their costs.
Participants say addressing these obstacles will lift the adverse toll on operators and ease the unhealthy pressure on the judiciary. Kemi Falademo, TVC News, Lagos.